Happy New Year from the Case Flash team. This is the first edition for 2014 of Case Flash, and we are going to be concentrating today on the changes to the rules of practice that became effective on January 1st. We're going to start with the changes to the professional conduct rules. With me today is Alan Palmer. Alan, how did they change Rule 1.6, which deals with confidentiality?
Rule 1.6 was changed in two substantive manners. In the first instance, Rule 1.6 was cross-referenced to Rule 1.10, dealing with the screening procedures involved in the change when a lawyer joins a new law firm. And the rule recognizes that to a certain extent, certain confidential information may need to be disclosed to determine whether a conflict exists when a lawyer changes from one firm to another. The second change in Rule 1.6 has to do with the inadvertent disclosure rules. 1.6 deals with the inadvertent disclosure from the disclosing attorney's standpoint, and similar changes were made to Rule 4.4 dealing with inadvertent disclosure from the receiving lawyer's standpoint. It places affirmative obligations on both to minimize any collateral problems that may be caused due to an inadvertent disclosure of confidential information.
Right, which is something that I think people are always worried about, and I think it's nice to have it in the rules, making it clear that people do have affirmative duties to try to mitigate the damage that kind of inevitably might happen.
I think also it's a recognition on the part of the Rules Committee that our profession is really becoming more of a transient profession. While we all would like to be with the same law firm throughout our entire careers, lawyers move around these days, and because we're a relatively close, geographically located bar, conflicts do come up simply by changing jobs or changing partnerships.
Right, and the practice book has pretty much codified the rule that emerges from the case law that's been around for a number of years about basically building that Chinese wall, which is what the cases refer to as the screening process and the ability to seclude one lawyer from information or activities that would otherwise create a conflict.
It also brings us more in line with the model rules, which
Right.
most of the other states have already adopted.
Okay. What's the next rule that you think we should be taking a look at?
In the practice book area, there were substantive changes made to Rule 10-31 having to do with motions to dismiss. Motions to dismiss, typically to oppose a motion to dismiss, a brief or opposing affidavit had to have been filed at least 5 days before the hearing. Now the party objecting to the motion to dismiss has a full 30 days to object.
Right, and I think that's a good idea because certainly in civil cases where you get a greater number of motions to dismiss, and in family cases where they might come up, that idea that you had to file your opposition or give notice of your opposition 5 days before the hearing just led to requests for continuance. And so pretty much you were at 30 days anyway. This is a kind of more civilized way to say to people, this is an important event, people need some time to prepare.
Yeah, yes, I think also one thing that needs to be noted is that while the changes were made to the civil rule 10-31, the rule has not been made effective as of this taping to Rule 25-13, which deals specifically with motions to dismiss in family cases. I'm assuming that's a technical oversight and will be corrected in the next version of the rules.
Yeah, I mean, I think that most people would concede, unless you had a litigation purpose, I'm not sure you would concede this, that family cases are civil, right? Well,
They're
at least
supposed to be
there's
civil.
civil litigation.
Exactly. There were two areas in discovery in the new practice book rules that have significance to family lawyers. In the first instance, Rule 13-1 was amended to include specific definitions of the term document and things and information that's supposed to be produced. From my experience, many lawyers in the area where I practice have used these definitions for years, but they haven't been codified until now. Now the definition of document has been standardized under 13-1, and while there's no affirmative obligation to recite Rule 13-1 in your request for production, it incorporates it by reference by the terms of the rule.
Right. And I think the next one would be 13.3, is that the privilege log revisions?
Yes, if there's a claim of attorney-client privilege or work product, the rules now require, similar to what's been going on in federal court, is a privilege log is generated by the person claiming the privilege, so the judge can rule on an item-by-item basis as to whether the privilege should apply or not.
Right, and the rule sets forth all of the information that has to be contained in that privilege log. So basically, for people who haven't either litigated in the federal court, who haven't had a discovery master or a judge order a privilege log, because certainly that's been happening in cases already pending, basically the document is described in a way to give the other side a sense of what might be in it, when it was created, who might have been parties to it, without giving you the substance of the document. And there is a safety valve in the rule as well, where it indicates that you can be released from including something, I believe, in the privilege log, if actually including it would somehow destroy the confidentiality or privilege of the document. So you'd be able to describe it in a way that you knew something was there, but you couldn't go further.
What also is interesting is the Rules Committee have excluded non-parties from 13-3. So a non-party would either have to ask for permission,
Right.
or one of the parties would have to ask for an order requiring the non-party to produce such a privilege log if privileges are claimed.
Right. Right. And it's interesting because privilege logs have also been used to protect, particularly for third parties. This isn't included under 13.3, but third parties often want to create logs where they are trying to protect confidential information as opposed to privileged information. Confidential information like trade secrets or business information, where competitors might be able to use it if it became public.
Which is a totally separate part of the practice book under 13-4,
Right.
not 13-3. Lastly, there was a change to 25-61 of the practice book, which now precludes lawyers for the parties or the lawyer for the children from contacting any custody evaluator appointed in the case, whether privately retained or through family services. Effectively, and you and I discussed this in our production meeting, effectively the only person having access to the custody evaluator other than the actual parties and the children is going to be the guardian ad litem. And you and I discussed that, I think, intentionally or unintentionally, by not specifically excluding the guardian ad litem, where the Rules Committee has given the guardian more of a control on how to direct the custody evaluation.
Well, it's going to be interesting to see if it plays out that way. I think the guardians have always had a fair amount of input in terms of giving information or expressing some of the concerns to the evaluators. The question is that they may be the only person doing that now, and then what emphasis will that give? I mean, I think the other interesting thing in this is, and this arose in discussions in the Family Commission in terms of what rules needed to be addressed or changed. And there had been such an increase in communication by lawyers with evaluators or family relations people in an effort to lobby or continuing to submit information, that there were certainly private evaluators who no longer wanted to do evaluations because the relationships could either would often disintegrate in terms of their refusal to take some of the information, and things became increasingly hostile. Or the family relations officers felt they were in an awkward position. So this was an attempt to really try to make sure that the evaluations remained as untainted as possible by legal input, and became what they were supposed to be, just evaluations of the parties and their kids. Because what we were buying inside of the court proceedings was a lot of examination and cross-examination that involved the conduct of the attorneys vis-a-vis the evaluator, and it was a side issue which took up a lot of time. All went to bias, or it went to what information they received, and it was unnecessary. And so I think it's going to be a relief. It's going to be interesting to see whether or not the guardian ad litems are relied on to a greater degree.
I think also the practical effect from family services and from the custody evaluator side is if they're not taking these extraneous phone calls from the attorneys, then they possibly can get their evaluations done in a more expedient manner, given the backlog that's going on in the judicial department as we speak. These rules go into effect January 1st and affect the substantive practice as well as the procedural practice of law. Additionally, the Rules Committee made changes to the ability for limited scope representation and filing limited appearance by attorneys for specific tasks. That issue will be dealt with in a separate case flash subsequent to this one.
Right, we didn't want them to think we forgot about that, right, Ellen?
Right.
Goodbye from the Case Flash team.